Good afternoon. My name is Krista Barth. I am an attorney. I am licensed in Florida, New York, Maryland, and the District of Columbia. I have been practicing law for 21 plus years, and I have a background in commercial litigation. I am a lake person. I've been coming to this town for 47 years, and I am very close to this town. I have reviewed the leases. And first, I need to say that this is not intended to be legal advice to any of you directly. What it is intended to do is encourage all of you to seek counsel and ask good questions to make sure, irrespective of your position, that you are well informed and protected. Despite my background in complex commercial leases and complex commercial litigation, this is an extraordinarily complex lease. I will briefly summarize some of the major issues as to why I wouldn't sign this lease as it's written. Section 1.2 talks about the project. The final boundaries of this project shall be determined by the tenant in its reasonable discretion. That is a very general statement. What that means is that this project can be put anywhere this company decides it wants to put it. They can go anywhere on your property, they can go anywhere on your land, and we'll discuss it further in some of the other provisions of this contract. Section 4.14 talks about the tenant's right to generate audio, visual, and electrical effects, as well as shadow flicker, radio interference, and/or other effects. That's very concerning to me, as that's a very general statement and we don't know what other effects might be caused by the installation of this project on your property into this town. But here you are giving the tenant the right to do these things and affect your property in the ways that are listed here and in other ways that are not specifically listed. These are other effects attributable to the operation of wind facilities or any other activities of the tenant, and allow the rotors of the wind turbines located on adjacent properties in the project to overhang on the premises. What does that mean to you? That means that not only when you sign up to be a landlord in this project will they affect your property, you are now granting them access to your property by your neighbor's wind turbine. There's no additional compensation provided for the overhang of this project onto your property from somebody else's property. Section 4.1.5, you allow the tenant in this case to undertake any other activities, whether accomplished by the tenant or third parties, that the tenant deems necessary for the development and operation of the wind facilities. That is, again, a very general statement. You need specific explanation from your lawyers as to what they mean by any activities deemed necessary by the tenant. That could be knocking down trees, that could be moving your stable, that could be moving your farmland. The possibilities to the interpretation of this section are virtually limitless. Section 4.2, ownership of the wind facilities. Tenant shall at all times retain title to the wind facilities and shall have the right to remove them at any time. Landlord shall have no ownership, lien, security, or other interests in the wind facilities. In my review of commercial leases over the years, we like things like liens. We like security interests. Security interests are a good thing. It means that if I'm the landlord and you come on my property and you don't pay me, I can take your tractor. I can take your car. I can take part of your livestock that you are farming on my land. That's something we all understand. A lot of people lease out their property for people to come in and grow their crops or raise their cattle on our property. And we oftentimes get a security interest. That way, if our tenant doesn't pay us, we can come take their cows and their pigs and their chicken and their crops. This tenant will not allow us to take anything that belongs to them. So if they don't pay you, you have no right to a security interest in any of the property that is on your land. Further, it says, landlord expressly waives, relinquishes, and quitclaims any lien or security interest in and to the wind facilities or any other real or personal property of the tenant in law or in equity. To me, that is a waiver of your ability to go after the tenant for, again, for issues of default, for issues of non-payment. You are not allowed to go after other real property to secure a judgment you might get against them. You're waiving it here. Landlord shall not have ownership in any and all credits, tax credits, benefits, omissions, reductions, offset, and allowances of any kind related to the wind facilities. Make no mistake that one of the most important things related to these wind turbine projects are the tax credits received by the companies for not the generation of power, but for building the facilities. You are entitled to none of these. You won't get any piece of it. You won't get a percentage. You will not get an abatement or an offset on your property taxes. In fact, they will do a calculation and apportionment of the alleged increase in your property taxes, and maybe they'll pay that piece. But you're still going to pay your property taxes in this scenario while they receive countless dollars in federal tax monies related to the project existing on your property. You don't get any of it. 4.3 talks about right of access. And right of access sort of correlates to the section 1.2 of the project, meaning that the final boundaries of this project shall be determined by the tenant in their reasonable discretion. This is, tenant shall have the right of access over and across portions of the premises, and here's a great one, and any adjacent land owned by the landlord. What that means is if they sign a lease related to parcel A and you own parcel B, by virtue of this lease, they have access, right of access across all portions of your land wherever it's situated. No restrictions on the tenant as to right of access to your premises. Section 4.4 talks about no warranty of energy production. Lots of people have been given these sample charts that show over the years the amount of monies that they're going to receive. You have no guarantee above the annual minimum rent. If this thing works and it generates power that's sold, you get your check. If it doesn't move, if it catches fire, if it's non-operational, if the power is not needed, you're not going to get your money. Anything above the minimum rent. Section 4.8, review of wind turbine locations. The landlord can object to the tenant's site plan, and then the tenant will consider wherever reasonable objections to the site plan. That's another very general open-ended statement. And what that means is when they come into your property, you can say, well, I would like it to be on the northwest corner of my property because I don't want to see it, and I don't want shadow flicker, and I don't want it to bother my horses and my pigs or interfere with this land that I have worked so hard to get ready to plant a certain crop. They can say, well, that sounds reasonable, and you better have a good reason because otherwise it doesn't matter at all. They'll consider that wherever reasonable, and then they'll put it wherever they want. Tenant may locate the wind turbines anywhere on the premises and within 100 feet from locations shown on the final site plan. Count out 100 feet. It's quite a distance. So they can move this site plan without your permission within 100 feet one way or other in any direction. Section 5.10.3. This talks about audit. An audit is an analysis when you get your check and it seems a little bit small to you that month. Then maybe the next month it looks small. Well, these audit expenses are on the landlord initially. What does that mean? That means that I have to go hire an accountant. Gets to be an accountant of my choice, but I have to hire a certified public accountant. And lawyers are expensive, but accountants are nipping at our heels. This is an expensive endeavor. You, now that you've hired your certified public accountant, get to send them to the location where the documents are. Apex is not a New York corporation. Apex is a Virginia company. Maybe the documents will be in Virginia, but they can store their documents anywhere they want to in this country. They might be in Utah, for all you know. But wherever they are, that's where your hired CPA is going to travel to perform this audit. The expenses will be on you for their time, their travel, their flight, and you cannot make copies. So the audit has to be performed in the location where the documents are. So you have to have your accountant sit there and sift through piles of paperwork without the ability to make the copies that they need and take them back to the office and deal with them. No copies of documents are allowed to be removed from the audit location. This will make sharing the costs of an audit impossible. You will not be able to get your neighbor A and neighbor C to come with you and hire the same accountant and send them to do the audit, because the confidentiality provisions in this will make that virtually impossible. You can share the information with your accountant, but you can't share it with your neighbor. The audit is subject to the confidentiality agreement being executed by your CPA and auditor. So that means when they come and they see something, they cannot go back and share it with anybody else. The audit expenses will only be reimbursed if the audit results in a 3% underpayment by the tenant. What does that mean in practical terms? That means that unless you find a 3% underpayment, you're going to pay all of those expenses, and you're not going to know until you've already expended, $10,000, $15,000, $20,000 performing this audit. And if they were underpaying you by 2%, you're not entitled to those expenses to be reimbursed. So if 2% of the value is $10,000 and you spent $15,000 on the audit, well, then you're out of luck, because you will have spent more on the audit than you would get back from the audit. Section 6.1 provides that the tenant shall pay all claims for labor and materials and not permit liens on the premises. That sounds terrific. We don't want liens on our property. We like liens when they're securing property to protect our interests, but we don't want liens on our property. That makes our property impossible to sell. It devalues the property. It causes a lot of complications for people. We don't want liens. So that's nice. Apex says we're going to make sure we don't get any liens put on your property. We're going to pay all claims for labor and materials, and we won't do this to you. But then you read that in conjunction with Section 6.2. And Section 6.2 provides that the landlord has the right to discharge the lien from their personal funds. Well, I don't know about you, but if somebody comes in to pour $150,000 of concrete on my house and they don't get paid, I don't have $150,000 to pay off this lien. So if they're coming in, big contractors laying rebar, cement, all of these are going to be farmed out to likely independent people. They're going to come in. I don't have the ability to pay off this lien. I don't have the ability to do it. And if the company doesn't pay the lien, that's not really helpful to allow me to go chase the company for this huge lien on my property because they didn't pay the guy in the first place. So we can seek reimbursement from Apex, who may have failed to pay its obligation in the first instance. I would ask your lawyer to investigate if there are, in fact, any occasions where this has actually happened. I have not verified this, but I do hear that there are some occasions where these liens have been put in place, and I would ask for a representation from the company that this has never happened under Section 6.1, and that in the instances where someone has had to reimburse for a lien, that they've been paid back. Section 6.3 is maintenance of the premises. This talks about restoration to damage of the premises disturbed by the tenant only if commercially reasonable and only upon completion of constructing the wind turbines. There is no requirement that they complete the construction within any set period of time. We don't know if it's going to take them 6 months, 12 months, 18 months, 2 years, 5 years. We don't know how long it's going to take them. But during that period of time, they don't have any obligation to restore my premises. So if I've got problems, if I've got big ditches, if I've got things that have been displaced, they don't have to fix that until they're done with construction, and we don't have an end date in the lease that I've reviewed. So that's another thing that I would ask people to be very careful of. The other issue is this commercially reasonable. What does that mean? There is no definition per se of commercially reasonable. And what commercially reasonable means is if it costs me too much money to go do this, if it doesn't benefit my company more than it costs my company, then it's not commercially reasonable. If it costs too much money, I don't have to do it. That's what commercially reasonable means. Section 6.6 talks about roads. The tenant can place its roads anywhere on the premises, and landlord has no right to use or obstruct the tenant's use of these roads. What does that mean? Well, think about it. If you have a large piece of farmland and they decide to run a road right through the middle of your property, how are you going to cross over it? How are you going to deal with it? How are you going to deal with the fact that your crops and animals have been displaced? How are you going to do your hunting when you can't cross roads that belong to you? Or they go through an enormous swath of trees and ruin the bucolic nature of your property. They can do it. You've given them the right to build roads all across your property. They technically could be right outside your front door. You could have them right through your crops, right through your barn, right through your front door. That's what you've allowed them to do under this provision. 6.7 talks about crop and livestock damage. The last time I checked, we're a farming town. This is very disturbing to me. Section 6.7.1 provides tenant shall reimburse landlord one time, for all damage to cropland, crops, and livestock. This is not just damage that's done during the construction phase. If you look at 6.7.3, it specifically says that tenants shall not be responsible to compensate landlord or its agricultural tenants for soil compaction, inability to grow crops, raise livestock, or otherwise use the premises as a result of the construction, maintenance, or operation of the wind facilities on the premises. These wind turbine projects are slated under this lease to go for 49 years. So for 49 years, if you can't farm your premises, if you can't raise your livestock, or otherwise use your premises, live in peaceful enjoyment, hunt, do anything related to your premises, they're not responsible to compensate you. This is, to me, one of the most concerning provisions. This is the one I would hit with a highlighter, take it to your lawyer, and make sure somebody gives you a guarantee that your right to enjoy your farmland will not be interfered with by this wind turbine project. Section 7.6.3 talks about representations and warranties. These are promises that the landlord makes to the tenant and the tenant makes to the landlord concerning in these representations and warranties are that the landlord indemnifies the tenant. That means I pay their damages, including attorney's fees, for hazardous materials, past, present, and future on that property. A lot of these farms have been around a long time. We don't know what's under the soil. We don't know what's behind the barn. We don't know what's there. But remediation for hazardous waste is incredibly expensive. Just look at the fact that Crosby Whipple is just sitting there. We can't just turn it into something else because there has to be very expensive remediation done to this property to allow somebody to come back in and utilize the property for something else. And it says here that landlord shall, at its sole expense, remove any hazardous materials located on the premises. That could cost you more than the entire amount of money that you are slated to receive under this lease. It could be in the hundreds of thousands of dollars. You are agreeing to an absolutely unknown figure. I would say that if you're looking at this and this is something you're interested in, you need to talk to your lawyer and you need to make sure that this is defined and that your obligations are capped. We don't agree to open-ended damages like this. Section 7.7, subordination and non-disturbance. These are complicated issues, but this lease requires the subordination of mortgages. What does that mean? That means that Apex lease comes first and any other mortgages have to come second. That's what subordination is. So the landlord, you, the landowner, is not entitled under this lease to get a new mortgage. A new mortgage would be a refinance. That's a new mortgage. A new mortgage would be a home equity line, an equity line of credit. That's a mortgage. That's a mortgage that's second in time after your Apex lease. Or if you need cash, some people have to do a reverse mortgage on their property. That would not be allowed under the terms of this lease. A lot of people are saying that the banks would continue to give mortgages even with a wind turbine lease. That may or may not be true, but I'd certainly check with my lender, because if you don't subordinate this, you're in violation of the lease. If you do subordinate this, you're in violation of your mortgage terms. When you violate your mortgage, you'll read in it very carefully that it says they can ask for all the money they're owed right away. That is a huge risk that I'm not sure that I would be willing to take. This would mean that your premises can't be sold to someone who would need a mortgage. It substantially reduces, if not completely eliminates, the possibility that purchasers of the premises would even be able to buy your property. So I don't have $250,000 cash to come buy your property, but I can get a mortgage. Only I don't know if I can get a mortgage, because unless I'm going through one of the lenders that might allow this, how am I going to get a mortgage? Heirs of the landlord are also subject to these substantial restrictions. These things go on and on. Section 8.1 talks about insurance. In this, Apex says we will get a $5 million general liability policy for your property. That sounds great. That's terrific. So if somebody gets hurt, we've got a $5 million insurance policy on there. Except there's a little provision that says that the tenant may self-insure to replace the requirements for a $5 million commercial general liability policy. There is no requirement in the lease for a protection of the funds in a self-insured scenario. So you have no way of knowing if the funds that will ultimately pay that obligation in a self-insured scenario are going to be there. Section 9.1, this is very concerning. You don't know who your tenant is going to be. And it says it right here. Tenant's right to transfer. Tenant may transfer without notice or consent of the landlord. They don't have to ask you. You don't even have to know you're not dealing with this Lighthouse Wind anymore. You could be dealing with Bob's Industrial Turbines next week out of Poughkeepsie. You have no idea who you're dealing with. Well, I don't know about you, but if I am going to have a tenant in my property, I'd like to know who they are. I'd like to know that they are a commercially viable company, able to meet the obligations that they have made to me. And there's nothing in here that requires that they assure that the transferee is commercially viable or able to meet the obligations under the lease. That sounds a little open-ended to me again. The initial tenant, Apex, would then be released from all obligations on transfer. Well, I don't know about that. I don't know if I want to make sure that they're still on the hook. That if the transferee doesn't do what they're supposed to do, I'd like to be able to go back and knock on Apex's door and say, hey, you guys are the ones that made me this promise. How about if you guys pony up the money for the damages that I might have? Section 13.7. I am the granddaughter of a lawyer, the daughter of a lawyer, the sister of a lawyer, the cousin of several lawyers, and the mother of a lawyer. So the jury trial waiver, maybe because I'm somebody who still walks by the Supreme Court and gets a little teary-eyed, is very concerning to me. We have enough people in this town that understand that one of the most important things about our system is a right to a jury trial. We are waiving our right to have individuals of this town determine damages in the event of the default by the tenant. I don't know about you, but look around. These are your neighbors. These are your friends. These are your peers. These are the people I want. If there's a problem and somebody has not treated me the way that they said they were going to under this lease, through a default, through causing health issues, through protecting me in a lawsuit by my neighbor, I want all of this to be in front of a jury of all of you. They don't trust you to make a good decision, or is it that they're concerned that because you live in this town, because you will ultimately, if this project goes through, be seeing issues and knowing that there are effects to the town, they think you might be just too sympathetic to the landlord and not sympathetic enough to the tenant. Jury trial is the most fundamental right that we are given in our legal system. Section 13.8. Okay, here's another one with some lawyer talk. Waiver of certain damages. All damages other than direct damages are waived. There is a waiver of punitive damages. This is a very important provision that's being waived here. And you'll notice both your jury trial waiver and your damages waiver are in big, bold, capital letters. Punitive damages are how we get big companies to behave themselves. The way I explain it is this. Think back to Big Tobacco. I have an uncle. His name is Bob. Uncle Bob smokes for many, many years, and then poor Uncle Bob passes away from lung cancer and other things related to his smoking. And the jury comes in and says they think my Uncle Bob's life might be valued at $500,000. Well, $500,000 isn't anything to Big Tobacco. It's a slap on the wrist. So how do you get a big company to stop doing intentionally bad things? Because that's what it has to be for punitives. They have to do things that they know are bad, that are intentionally bad, and it subjects them to punishment. Well, in this situation, we have punitive damages. So a jury comes in and says, well, Uncle Bob's life might have been only worth $500,000, but because this company did a very bad thing, we're going to hit him for $500 million. Well, now we're talking. Now people are starting to crunch numbers. Now people are looking at what changes can we affect to make the bad stuff stop. Punitive damages are how we protect this town. Punitive damages are how we protect ourselves from health issues that may happen, from all of the things that could potentially happen. And if they're not going to happen, and if they're not a possibility, then why are we waiving them? You know, I've seen signs around town that say, fear not the wind. And my comment is, fear not punitive damages. If you're not going to come into this town, my town that I love, and do something that is intentionally wrong that will cause a harm to people, you don't need to worry about a punitive damages provision. So I say I wouldn't sign a document that waived my right to a jury trial or waived, more importantly, punitive damages. Actual damages in this case will be insignificant to a large company to affect a change in any of their policies or procedures. We are a tiny little town here, and we're dealing with a big corporate giant. Section 15.3, restoration of premises. Here we go again with commercially reasonable. The tenant's requirement to restore the premises is only to the extent it is commercially reasonable to do so. Definition of commercially reasonable: it costs me more money than it's worth, I don't have to do it. Who's going to determine commercially reasonable? What that tells me is that we're going to have a litigation. And litigation is very expensive. It's exceptionally expensive to protect yourself with legal counsel. So if I get into a situation where there is a problem and my property has not been restored, I have no other recourse than to sue this company, hire my own lawyer, sue this company, and then we get to have somebody decide, not a jury, by the way, what commercially reasonable means in this scenario. It is likely to result in expensive litigation to enforce your rights under this, and actual damages is all they're ever going to pay. Yeah, there's provisions in there that talk about, well, you know, they'll come and they'll remove this thing and we'll subtract out the scrap value of this. Ask this company, have they ever removed a wind turbine? And how much did it cost? Because I'd like to know. In this contract, it says, well, if they don't bring the wind turbine down, I can do it myself. I can go, you know, hire a couple guys, 30, 50, 100. I can get myself some semi-trucks, and I can remove this wind turbine. I can do that. How much is it going to cost me? I don't know. Is it going to cost me $50,000, $100,000, $1 million? I have no idea. But what I do know is this: unless I know the number, I don't want to sign a contract that says that, well, they could remove it if it's commercially reasonable, but if they don't, I can remove it. And then I can go back to them and I can get my damages. Because otherwise, my actual damages are only the value of my property. And the difference between having an old, broken down, rusty wind turbine on my property that's almost 600 feet tall, I don't know. I would like them to answer the question. And the best place to get that question answered is in your lawyer's conversation and a written representation from Apex as to how much it's going to cost. I'd like the money in the bank. I'd like an escrow account. Everybody understands the concept that when they rent out their house, they take a security deposit, put it in the bank. It sits there. And at the end of the lease, if there are problems, I get to go to the bank and I get to use that money to replace the carpeting and the paint and all the damages done by the wild parties of my tenant. In this situation, where's our pot of money going to be? Do I have control over it? Do I have access to it? Do I have to sue them to go get the money out of the pot? Who's going to be the person that holds that money? These are all really important questions, and you want to make sure that you're protected. Confidentiality. Let me be very clear, because a lot of people don't understand how it is that I'm even able to review a contract with Apex that has been passed out to a potential landlord. You are only subject to the confidentiality provisions if you're party to the lease. Once you sign on the dotted line, you can't talk about this lease. Not with your neighbor, not with your best friend, not with your parents, not with your children. This is a confidential lease. We have people who have been kind enough, after being approached, to give us a copy and say, here's what this is and here's what's going around. So there's no confidentiality breach prior to signing this. But if you sign this lease, you cannot discuss it with anyone other than your lawyer, accountant, and financial advisor. In fact, there's an interesting provision in there that says if you go to sell your house, only upon a written offer can you disclose the contents of this lease to somebody coming in to buy your house. Well, let me tell you this. If I'm coming to buy your house and you are tied up in a lease, I'm not making an offer until I read that lease. That's absurd. So that's another provision that needs to come out of the contract, in my opinion. I've got to be able to share it. I'm not sure why they have a confidentiality provision, but I don't like them. We're neighbors here. We're friends. We all know each other. And if we're going to do these leases, then we need to make sure that me and my friend down the road get the best darn deal that we can. And if I'm getting paid more money than he's getting paid, we should be able to talk to each other so that we can deal with this big company with lots and lots of money on an even playing field. If we talk about the terms, if we talk about the contents of this, if we talk about the potential implications, this is an incredibly serious lease. And the fact that they don't want me to talk to you, but they won't let neighbor talk to neighbor, we have to ask ourselves, why? What is the benefit to us? There's no benefit to us. It's a benefit to them. Landlord cannot disclose any information concerning the lease to the press or the media. That one's self-explanatory. Again, ask yourself why. What's the big secret here? Why is this being done behind closed doors? Why aren't these leases filed with the county? The only thing that's filed are the memorandum of leases, which are a little summary of the lease. But that's not the lease. I want to see your lease, and I want you to see my lease. I think that's something that should really raise red flags to a lot of people. Section 16.17, setback waiver. The landlord waives all setbacks, including a waiver that would allow your neighbor to violate setback restrictions affecting your property without any additional compensation. This includes that you are required to execute in favor and deliver to the tenant, to Apex, one or more separate setback waivers or easements in the form that's provided by them, not in the form that's approved and reviewed by your lawyer or negotiated. They're going to hand you an easement and they're going to tell you you must execute it in its current form. That's very concerning. You will not be given any additional compensation. That means when they say, okay, we're going to have a 1,200-foot setback from these wind turbines, not for you, not for you, because you waived the setback. So not only can it interfere with your setback, but if you have a right to have a certain setback from your neighbor's turbine, you waived that too. So you could have this right up against you because you have no right there. The best part about this one is it survives the termination of the lease. For so long as wind turbines exist on adjacent properties for no additional compensation. What does that mean? That means if your lease is over, if they've defaulted and you get out of your lease or somehow you wiggle yourself out of this lease, they still have the right to impinge on your property by your neighbor's wind turbine. There are general comments regarding health issues, loss of value, giving up control, use, and part of your premises, the ability to mortgage and sell the premises, the limited responsibility for the tenant, and limited and inadequate resources of recovery upon default. You waive many important rights that are not customarily waived in a commercial lease. The landlord will incur the full cost of litigation if sued by their neighbor or town and will be solely responsible for resulting judgments. Who will your tenant be in the future? All of these are good, strong questions that you need to discuss with an attorney who is not a general attorney. I am not a wind attorney. I am just an attorney who has some experience in commercial litigation. You need someone who knows real estate, who understands easements, who understands the implications of a lease such as this, and I wish you all the best.